Hello guys and welcome to the LawPutra's YouTube channel. Today we will discuss about the difference between tribal areas and scheduled areas in Indian Constitution. I am Jagannath Kulkarni and we will discuss this topic today. Difference between tribal areas and scheduled areas. Can we do this in tabular form? Let us see. Tribal areas and scheduled areas, they have been defined in the Constitution of India 1950, Part 10 of it. And Article 244 talks about these two things. It gets two clauses, Clause 1 and Clause 2. The heading of the article is Administration of Scheduled Areas and Tribal Areas. Then Clause 1 talks about the provisions of 5th Schedule which shall apply to the scheduled areas, administration as well as control. And scheduled tribes also in any state other than 4 states. Those 4 states are northeastern states, that is Assam, Meghalaya, Tripura and Mizoram. Clause 2 talks about the provisions of 6th schedule which shall apply to administration of tribal areas in these 4 states, northeastern states, Assam, Meghalaya, Tripura and Mizoram. So this article 244 describes about these two things, tribal areas and scheduled areas. Now the question that comes to the mind is why these two areas, tribal areas and scheduled areas, they are treated differently. Why? What's the reason? Tribes of these 4 states, Assam, Meghalaya, Tripura and Mizoram, they have not absorbed the way of life of other people of those states with time. They are not changed with time. Somehow, tribal areas of other states have adopted culture of other people, more or less. But tribes from these northeastern states, they stand connected to their own traditions, culture and custom. And therefore, such areas are treated differently because the constitution has provided sufficient provisions to provide a sizable amount of autonomy. See, this is the federation of states. Again, in states, we have this discrimination. Can we call it discrimination? To practice their own way, we are giving them autonomy, not discrimination, but the autonomy. But the most important part is without hurting unity of the country. And that is the most important part of it. Again, if we talk about the scheduled areas, which are different in these four, other than these 4 states, these scheduled areas, they have been inhabited by people who are socially and economically backward and consisting a part of the country, though they constitute a part of the country. And therefore, it is the responsibility of the government which talks about the welfare state to make special efforts needed to improve the conditions of these scheduled areas. And therefore, normal administration system which is running across the country may not be suitable for these areas. And it requires special attention and effort, these scheduled areas. And therefore, the government has greater responsibility for their welfare. Now, see the tribal areas we have already discussed. This is among the 4 states, Assam, Meghalaya, Tripura and Mizoram. What about the scheduled areas? It covers the 10 states and these states are Andhra Pradesh, Telangana, Jharkhand, Gujarat, Chhattisgarh, Himachal Pradesh, Maharashtra, Madhya Pradesh, Rajasthan and finally Odisha. So these 10 states, they are covered with these scheduled areas. What is the criteria for declaration of this area as scheduled area in these 10 states? Number one is preponderance of tribal population. That is the first and foremost. Second is compactness and reasonable size of area. It should not be too wide, too large. It will be difficult to control. And a viable administrative entity such as district, block or taluka, it is available there. And lastly, economic backwardness of that area has to be established as compared to the neighboring areas. So these four are the criteria which is helpful for deciding any area as the scheduled area in these 10 states. Now for tribal area, we have the division of land, and as the 4 states are there, we have the 4 parts. First part is for Assam, second is for Meghalaya, second A is for Tripura, and part 3 is for Mizoram. Assam will cover North culture cells, then Korbi and then Bodoland. Meghalaya will cover Khasi, Jantia and Garo. Tripura will cover Tripura tribal areas and Mizoram will cover Chakma, Mara and Lai. So these 4 parts and these again the 10 areas are covered in these tribal areas. Division of land is done. Now tribal areas, we have the administration differently. These are to be administered as autonomous districts, but not outside the executive authority of concerned state. Executive authority is again predominant permanence. Organization and reorganization. This reorganization will include increasing or decreasing area or changing the boundary lines. This can be done by the governor of that concerned state. And different tribes, the governor is authorized to divide the district into several autonomous regions, right? So autonomous states, then autonomous regions, autonomous districts, then autonomous regions. Then to exercise 2 functions, legislative functions as well as judicial functions in such areas, the district councils will be created, which will have 30 members, which are out of which 4 are nominated by governor. They will remain the members till the pleasure of governor. This is the terminology. And 26 are elected by way of adult franchise. And these members will be there for 5 years. Also, this is the district council. There will be regional councils as well in the same pattern. Then these tribal areas, these councils, they are having the law making power, which is very important. Other than state legislature and the parliament, these councils have got the law making powers. Councils law making power in certain domains, specific domains, which is have their culture, tradition, custom, management of forest other than reserve forest, marriage, social customs, inheritance of property, etc. Just like the personal law. And governor of state can provide power to try certain suits or offences, civil suits, criminal offences. Empowered to impose certain specified taxes, they can collect the land revenue also. So this much autonomy is available. Governor must approve the law made by council. It is required. Then, on the matters over which council is empowered to make law will be law of state legislature over such topics cannot be extended to such areas without approval of councils. These councils will have autonomy. State legislature cannot be imposed on these. And with regard to other matters, the President for Central Act, Governor for State Act may direct that an act of Parliament or State Legislature shall not extend or shall be extended with reasonable exceptions to any autonomous district. So again the Governor and the President will have those powers. Now see the power of direction. Again, we have bifurcated Assam as a separate state and then these 3 states in another group, Meghalaya, Tripura, Mizoram. For Assam, the governor will decide will give the power of direction whether it is an act of parliament or act of state legislature. But for Meghalaya, Tripura and Mizoram, we will have president for acts of parliament and governor for acts of state legislature. So this is again the difference is made in these among 4 states. Remember, treating the unequals as equals is as bad as treating the equals as unequals. So guys, today we discussed about the difference between tribal areas and scheduled areas in Indian Constitution. Thank you. Thank you very much.